Honorable, the judges of the United States Court of Appeals for the Fourth Circuit. Oyez, oyez, oyez. All persons having any manner or form of business before the Honorable, the United States Court of Appeals for the Fourth Circuit are admonished to give their attention, for the court is now sitting. God save the United States and this honorable court.
All right, good morning. You may be seated. Welcome to the Fourth Circuit. We're ready to hear argument in our first case, Stinney versus Holcomb. Whoever's arguing for appellate.
Good morning, Your Honor. May it please the court, my name is Tennille Chekovich, and I'm here representing the plaintiff's appellants on a pro bono basis. I'd like to reserve 5 minutes of my time for rebuttal. Following the first appeal in this case, Chief Judge Gregory remarked in his dissenting opinion that by suspending the licenses of those who cannot pay for reasons outside of their control, the state traps thousands of Virginians in a nightmarish spiral for which there is no apparent exit. Indeed, when plaintiffs began this litigation, they had a simple goal: to stop the defendant from unjustly punishing their poverty through the suspension of their driver's licenses without due process under Section 46.2-395. On December 21st, 2018, plaintiffs achieved that goal when the district court entered a well-reasoned and warranted preliminary injunction which changed the plaintiffs' lives. Plaintiffs meet the standard for qualifying as prevailing parties for a simple reason. The district court's merit-based preliminary injunction materially altered the relationship among the parties in a way that directly benefited plaintiffs. Before the injunction, plaintiffs suffered ongoing unconstitutional deprivations of their driver's licenses and the specter of hefty reinstatement fees to get them back.
And what would you have us do with our precedent in Smith?
Well, Your Honor, we do, as we've argued in our papers, we believe that the Smith case is no longer the prevailing law. Defendant would have the court deny plaintiff's petition based on Smith, saying that it creates this bright line rule denying fees in cases involving preliminary injunctions. But more recent Supreme Court precedent confirms that plaintiff's entitlement to fees is clear under the Lefamine case. As the magistrate judge found in this
case, Lefamine was a permanent injunction case, wasn't it?
That's correct. But if you apply the legal standards in Lefamine, there's no difference in the facts of that case and this one that matter. The plaintiff.
Well, I mean, one could argue that permanent versus preliminary injunction does matter.
Well, in this case, albeit very unusual circumstances where it was mooted, the case was mooted before it proceeded, there was no opportunity to go through continued proceedings. So the defendant, by seeking a stay, actually stood in the way of further litigation here. But the important thing is that throughout the entire time that the plaintiffs needed relief in this case, they had it from the court. So they obtained the preliminary injunction and it remained in place for months while the case was stayed and the legislature was doing its thing. What the legislature did, though, doesn't detract from the important relief that the plaintiffs obtained in the injunction.
Sure, and I agree. I mean, we've had a recent case that reaffirms that principle, that the legislature actions, probably aren't something that, for example, moots the case and takes away the entitlement. But there's got to be the entitlement there in the first place. And that's what I'm trying to figure out is, I think your point is well taken that, here, you may have been deprived of your chance to get to the level of an injunction that that would entitle you to fees under our current law. And maybe that's something we look at. But it seems to me we either have to overrule Smith, or which we can't do, or say that maybe the circumstances, where you're prevented from getting a permanent injunction somehow entitle you to it. I don't see how we can do anything else with Smith in the way.
Well, as we've argued in our briefing, the underpinnings of the Smith case have been washed away by the change in the preliminary injunction standard. So the Winter standard is much stricter in terms of its requirements on the merits. And Smith is very clear that it's focused on the balancing between the equities and the determination on the merits. And it's concerned about the fact that a plaintiff could get an injunction merely by showing that the equities are heavily in their favor
Counsel-
without a showing on.
Counsel, can I stop you? Because I agree with you that that's a big part of Smith's concern, but it does look to me as though Smith kind of went out of its way to clarify in those footnotes at pages 8 and 9, like, yeah, that may be what we're concerned about, but to be clear, this rule applies even if we're not applying our kind of sliding scale approach to preliminary relief, and whether or not a preliminary injunction rests on a merits-based finding.
To the extent that Smith goes beyond the injunction that was decided under the Blackwelder standard that was at issue in that case, that discussion in those footnotes is dicta, that this court is not required to follow. The new current standard on injunctions didn't exist at the time that Smith was decided. And so to the extent that that opinion attempts to reach that issue, it's simply hypothetical. It's talking about something that hasn't happened yet. And so, for instance, we could imagine a situation where the preliminary injunction standard changed again, and now it requires that you have to prove that you win your case, you win on the merits to get the injunction. Surely no one would be arguing that Smith still stood, because that statement that no preliminary injunction could possibly ever meet the standard for prevailing party wouldn't make sense in a world where the standard was you've proven your case. And here in this case, the plaintiffs did prove their case on the preliminary injunction. This was not a situation where someone went in at the very beginning of a case. We had experts, many witnesses testifying, and importantly, the judge's ruling was based largely on a facial constitutionality issue, something that can be decided based on the text of the statute and the law. And so,
But where is the, counsel, I think that's a fair assessment. It is a order regarding preliminary injunction that has a lot of characteristics of permanency to it or merits to it. So I think that's a fair description. But we'd have to find something that says, okay, we can look at preliminary injunction orders and kind of do a case-by-case analysis and say, okay, that's got enough merits to it, that one doesn't. And maybe the dicta argument is something that allows that, but it's hard to see that with our precedent. And so I think we come to the case, to me, of either, or it seems that either you have to side Smith's untenable, and maybe that's your argument, that it goes to the level of being untenable. But if you look at our Banks case and our Dodge cases, that's a pretty high bar. Maybe it's different now, but different is not the same as untenable. Or is it your argument that it is untenable?
yes, we certainly believe that it is. The entire basis of Smith is really revolving around the standard in place at the time under Blackwelder and the importance of the balancing test there. And it's reading a lot into those footnotes to say that it's a clear forever bar and no preliminary injunction could ever meet the standard, even if the Supreme Court has changed the preliminary injunction standard.
What do you do with our G case that's a recent case that applies Smith, well after Winter?
So Your Honor mentioned Dodge as well, and G is a case that you would talk about when looking at Dodge and the analysis in Dodge. This is not a case like Dodge, because here we do not have with Smith a case that has been relied upon in scores of opinions on the merits. If you look at the history of Smith since the Lefamine case, there have only been 6 decisions that cite it. None of them involve preliminary injunctions. So there is not a...
Wasn't G a preliminary injunction case?
No, it was actually an immigration case involving an unusual remand order.
Yeah.
And that's one of the many differences here. In G, the order was truly procedural. It set a calendar for deciding the merits of the case. It made no attempt to even touch upon the merits of the case. And here, obviously, the order was very different. The judge found that the statute didn't provide process and that process of some sort was required.
So is your, under your argument or theory of the case, what's the rule that you would have us adopt? Is the rule that we're not bound by Smith? We got Winter changes Blackwelder, so Smith's kind of in the rearview mirror. Now here's the new rule. Is your argument that you look at the order to see whether it's sufficiently merits-based and we decide on that basis?
We think this court should apply the language in Lefamine that says that a plaintiff prevails when actual relief on the merits of the claim materially alters the legal relationship between the parties by modifying the defendant's behavior in a way that directly benefits the plaintiff. And in doing so, what we would say is, in this case, clearly, the injunction reached the merits, and relief was given that was significant to these plaintiffs. Their licenses were no longer suspended. The DMV was prohibited from enforcing the statute against them, and he had to give their licenses back without charging them the reinstatement fee. That's obvious material relief. They were now able to drive without the fear of arrest for having a suspended license. And those changes are marked by a judicial order that has imprimatur. There can't be any argument here that this was the defendant's, voluntary conduct. The court ordered this relief in the preliminary injunction.
Counsel, can I ask you a question? I don't want to complicate your life further, but sort of our case law on this, we do have some case law suggesting that even a final injunction, if it is vacated, means that the party who won the final injunction is no longer a prevailing party. What would you have us do with that?
So you can look to the Soule case, which talks about what if you're, divested of your relief at some point during the case. And I would say that that certainly applies to preliminary injunctions in general. So in the Soule case, where you had a preliminary injunction awarded and then later the plaintiff lost, they were no longer prevailing. And that would certainly be the case.
But we see, I'm concerned, so the cases from other circuits that find that preliminary injunctions are sufficient, they sort of start from the premise, which is true in those circuits, that look, if you get a final injunction or final judgment with an injunction and it is later vacated as moot, you remain a prevailing party. But our law on that is at a minimum much less clear. We do have some cases at least suggesting that even if you win a final judgment with an injunction and it's vacated as moot, not overturned as incorrect, but vacated as moot, you may no longer be a prevailing party.
I guess my response to that, Your Honor, would be that in this case, that's simply not applicable. So I don't have that concern here because we never lost the injunction. It remained in place right up until the end, and then the parties stipulated the case was moot because of the legislation. But the court never entered any order that affected any of the relief the plaintiffs got. And that's the crux of the issue. This was an action by the legislature and not by the court. In his response, the defendant argues about the costs and benefits of amending a law or changing a policy. But when the DMV decides to defend an unconstitutional law and fights at every corner, it has to live with the decision when it loses on a merits-based preliminary injunction, even if the legislature later repeals the law in an apparent attempt to stop the DMV from continuing to incur costly legal fees. Section 46.2-395 trampled on plaintiffs' constitutional rights, and the district court rightly enjoined its enforcement. The plaintiffs are prevailing parties under Supreme Court law, and courts around the country are reaching that conclusion in factually analogous cases. This court should do the same. For these reasons, plaintiffs ask this court to reverse the decision of the district court, hold that plaintiffs are prevailing parties, and to remand the case for further proceedings based upon any standard this court should adopt.
Thank you. All right, Mr. Cox.
Thank you, Your Honors, and may I please the court, Trevor Cox from Hunt and Andrews Kurth on behalf of the Commissioner. I have 3 points to make in opposition to plaintiffs' arguments. First, under this court's binding precedent in Smith, which we've been discussing, plaintiffs did not achieve prevailing party status by obtaining a temporary PI. This court must follow Smith unless and until it is overturned or called into serious doubt by the en banc court or the U.S. Supreme Court. And my second point is just that the Supreme Court has not undermined Smith or called its reasoning into doubt. The 2 cases cited by plaintiff, Winter and Lefamine, simply do not have the impact that plaintiffs would like them to have. And the Supreme Court's denial of certiorari in a Sixth Circuit case a couple of years ago has no precedential value. Third, even if this panel could depart from Smith, and even if there were a reason to adopt a different rule, as some other circuits have, this is not a case in which a departure from Smith is warranted. So first, to be clear, plaintiffs are asking this court to ignore the binding circuit precedent of Smith that a PI alone does not make a plaintiff a prevailing party. And I don't think even plaintiffs...
I want to understand why, your third point, why you don't think that this is a case where it would be warranted that they're the prevailing party.
Sure. And I don't, to be clear, I don't think you even have to get to that point because...
Right, I understand, but what if we do?
If this court, or more properly the en banc court, were to think that some exception to the rule is appropriate, when you look at other circuits, they tend to fall into a few different categories. One is where the event itself has passed, where you have a permit for a protest or something, and then you get a preliminary injunction against the activity that's supposed to be restrained, and the event is over. So you've actually achieved what you wanted to have. Another is if the defendant agrees that the policy is unconstitutional, and that leaves nothing further to be done. That's the PAPV case in the Third Circuit and Select Milk in D.C. And then finally you have cases where it's mooted by a change in policy that is directly responsive to the suit. That's the Dearmore case in the Fifth Circuit.
That seems like this case.
Not so respectfully, Your Honor. And I think that's true for several reasons. First, it was repealed over, the reform effort that led to its repeal had been going on for years, many years, in fact. And the fact that litigation was happening at the same time, there was no causal link between the two.
Well, didn't the commissioner's letter asking the General Assembly, would you please act so we don't have to pay more attorney's fees in this litigation, tie the two things together?
I think that suggests a recognition that there was litigation going on, but I don't think that suggests that the legislators who voted to repeal the statute were doing so in direct response to the court's PI order.
Well, is it your understanding that in the circuits that apply some kind of a causation analysis, they put the legislatures on the stand in light of circumstantial evidence like that commissioner's letter, that they actually go, I guess, legislator by legislator and sort of delve into their motives?
No, I've not seen a case where that's happened, but for instance, in the Grabarczyk case that your honors are very familiar with, the legislature actually said, this is what we're doing. We are responding to this order, and we are creating a special class in response to this class of plaintiffs. That certainly would be very powerful evidence
Clearly,
that there's a causal link.
Can I ask you about the commissioner's letter? Because it gets to one of my concerns about your argument is sort of how the incentives work out if parties like the plaintiffs here are not prevailing parties. What my concern is that it would give the state sort of every incentive to fight even the most obviously meritorious claims, knowing that if they lose in court, if a preliminary injunction is entered against them, they can then turn around, ask the legislature, we lost, please repeal this so we don't have to pay fees anymore. The legislature does it and you're off the hook. I mean, why isn't that a real concern? And not just a practical concern, but sort of directly oppositional to the whole point of Section 1988.
Yes, I understand the point, and I think in a situation like that where that was a valid concern, you might make that a
But that is literally this situation.
I don't think so. So to be clear on the commissioner's letter, I think he said we don't want to pay attorney's fees for our lawyers, meaning us, not pay attorney's fees to the other side. I think that's what he was saying. And by the way, I think he asked I guess it was to Senator Stanley, to try to put an acceleration clause in there to get rid of the policy. That never happened. So it's not like he had a great influence on the.
The letter is directly connecting the litigation with the legislation, though. Do you agree with that?
Yes, he makes reference to the litigation. Yes. Yes, but that is to one legislator. I don't think that you can impute that to the entire legislature. And I think another point worth mentioning is that the legislature, if it was concerned about the constitutionality, and by the way, the constitutionality of the statute was never anything that was discussed in the legislature. I don't think plaintiffs have cited any evidence that in getting rid of the statute it was because of the unconstitutionality of it. But if they had been concerned about the unconstitutional provision related to notice, they could have tweaked the statute to fix that. That's what happened in Grabarczyk. They didn't toss the whole statute out. But that's what happened here, which suggests that over a long period of time, people had been pushing to get rid of what they thought was bad policy. Doesn't make it unconstitutional, it's bad policy. They got rid of the entire statute rather than just tweaking it to make it constitutionally sound. And I think when you look at the broader picture.
So they didn't just, appellants successfully accomplish that with the help of the commissioner's letter.
In one sense, appellants did because LAJC was litigating this case, but LAJC was also one of a group of advocates going back many years who were pushing for the reform. And once a party came to power.
And were unsuccessful in doing so until these appellants.
I'm sorry, Your Honor?
These appellants were successful where you're saying others weren't, right?
As lobbyists, as advocates, yes. I don't think you can read the record as the legislature responding to a PI order. It certainly didn't lead to an immediate change in the legislative approach.
Counsel, what's your colleague says that footnote 8 and footnote 9 in Smith are are not binding, they're dicta, and we're not compelled by that. And if that's true, maybe we look more at the policy underlying Smith, which might not be present here. What's your response to that argument?
Well, to the extent that the argument is that, well, actually there was not a likely to succeed standard that was required, that's just not true. If you look at the Smith District Court case, the District Court granted a PI based on the likelihood of success. And yet, this court in Smith said, we still don't think that that's enough. It's not a decision on the actual merits. It's a prediction of probable success, but it's not the same as success on the actual merits or actual success on the merits. So even if there was some thought that, oh, the Supreme Court might change this, and I think Judge Harris is right that they did go way out of their way to say it doesn't change our analysis, the fact that they did apply a likely to succeed standard shows that it didn't make a difference.
And it does seem like this situation, at least, if Smith is binding and applies across the board to preliminary injunctions, and if there is a subsequent legislative change that moots the case, is this just one of those situations that you say, hey, the way the cards fall, there's just not an opportunity to obtain prevailing party attorney's fees? That's just luck of the events of the case?
That's correct. I mean, that's certainly the effect of Smith, and I don't think that we can get beyond that. I mean, to return to Judge Harris's questions about the purpose, I guess, of the statute to promote vigorous enforcement of the civil rights statute, this was something that the justices in Buchanan debated, and especially Scalia in concurrence and Ginsburg in dissent. They went back and forth about this, and that's a slightly different situation, but Scalia basically said, well, of course it would promote vigorous enforcement if you allowed attorney's fees under catalyst theory, but we're not going to do it because you need a merit-based decision. Plaintiffs also say that lefamine somehow undermines the analysis in Smith, and I don't think that's true either. Lefamine, as Judge Quattlebaum, you noted, involved in permanent injunction, but it also applied the standard that had been in place for decades, the material alteration of the relationship between the parties. And Buchanan said, in order to have that material alteration, you have to have a merits-based judgment. And Smith said, a preliminary injunction is not a merits-based judgment.
May I ask you a question? You, in your brief, you sort of warn us off reconsidering Smith, not as a panel, maybe en banc, by suggesting that there's a lot of confusion in the circuits about it. Smith is a nice, easily applied rule, but there's sort of rampant confusion in the circuits about when exactly a preliminary injunction would qualify. But I looked at the standards that were laid out, and they did look to me like they were just kind of slightly different formulations of the same basic idea. It's merits-based, it alters the legal relationship between the parties, and it hasn't been reversed on the merits, and it can't be because the case is now moot. And so my question is there any indication in these circuits, and I take it this is every circuit but ours, that does not apply this kind of bright line rule? We are a true outlier on this. Any indication in these circuits that this has actually proven particularly difficult to apply? Because I didn't see any. I guess the most obvious indication would be judges writing opinions saying, oh my God, this is like an impossible standard, we shouldn't do this. But is there anything, it looks to me like it wouldn't be that hard to apply, but is there something out there that suggests otherwise?
Yeah, I can't point to internal circuit confusion or a court saying this is so difficult we can't do it. There's certainly some conflicting standards, and the circuits don't agree on what the standard is. But I think the virtue of a bright line rule like Smith, and this is something that gets at the policy reasons articulated in Supreme Court cases like Buchanan, is that you don't have to have a sort of separate litigation about, well, is this sufficiently merit-based? Is it something else? Do you apply a rule of reason? It's a very clean rule. That may not be satisfying, but that is one virtue of having a bright line rule.
This is maybe not like the right question to ask you, but you seem to know this case very well, so I will ask you. So we're the only circuit that takes this approach. Assuming hypothetically that I agree with you that Winter doesn't quite supersede Smith, it certainly addresses sort of the focus of the concern in Smith. Ought we rethink Smith? And understanding that we can't do that as a panel, obviously, but as a court, is it time to rethink Smith?
I think that the en banc court could have a very vigorous debate about whether, with Smith gone, the reasoning of Smith still survives. That a preliminary injunction is, at best, a prediction of the probable outcome. It relies at the PI stage. You have different evidentiary standards. You don't have full-blown evidence. And so the district court is making a guess, a good faith guess, about what the likely outcome is going to be. In some cases, perhaps you have a much better guess at whether a policy is unconstitutional or not, because the defendant, after the PI says, "Yeah, it's unconstitutional. We're gonna capitulate," and that's what happened in some of the cases that Your Honors have recently been on, Ray Azudin and Grabarchuk. That makes it a little bit clearer, but it's at best a prediction of a necessarily uncertain outcome. And so I think that point that I think it was Judge Williams in the Smith case, but on behalf of Judges Wilkinson and Motz, I think that reasoning probably still survives and has some serious weight. So I think we've talked about Winter and the importance of footnote 8 that specifically addresses the plaintiff's argument, and also the fact that a likely to succeed standard was actually applied there. And in Lefamine, again, the material alteration standard is something that had been out there for a decade or more, and so it didn't actually suggest a change in the law the way plaintiffs think. And then finally, the point they make about the Supreme Court denying cert in the Planned Parenthood case out of the Sixth Circuit. Of course, the Supreme Court denies cert for many reasons and has consistently advised that you're not supposed to take that as an indication of what would happen on the merits. So I don't think that the Supreme Court has taken any action that really undermines Smith. And in fact, as was recognized in appellant's argument, solely sort of left open that question. And so for the conclusion to be that they've sort of sub silentio.
And Sol predated Smith and Winter and Lefamine.
It did, Your Honor.
So
yes. But I think it would be really curious for the Supreme Court to recognize that it's an open question and expressly leave it open and then sub silentio, to use the term that plaintiffs do on page 53, to sub silentio overrule it. I think that would be very curious. I don't think the Supreme Court operates that way. Unless there are further questions,
Do you all have questions?
we ask that the court affirm.
All right, thank you. You have time in rebuttal?
Thank you, Your Honor. I wanted to address a couple of the questions that came up during the response argument. First, Your Honor raised some questions about causation and what does proof in these cases look like after the entry of the preliminary injunction to show prevailing party status. And I would direct you to the Dearborn case, which is actually the one that the DMV would like us to adopt if we move to a different test. We've argued in our briefing that we don't think a causation prong to the standard is necessary or appropriate because it does raise Buchanan-like concerns, although not truly a Buchanan issue. But if you look at how that Dearborn standard is actually applied in the Fifth Circuit in cases like Amawi, which is recent, a very recent case applying that standard, what you see is that the courts simply look to the timing of the events in the case and then infer the causation or the intent of the defendant or the legislature from that. So you don't see extensive discovery into legislators' motives. And in fact, the Amawi court noted that it wasn't clear that that prong 3 of the Dearborn test, would even apply in a case like ours where it's not the legislative branch, but it's actually the executive that is the defendant, because of course it's not the executive branch that's enacting the legislation. And so the first step from our position would be that we shouldn't have a causation requirement, and a more simple test like the one set out in Select Milk is easier to apply. But if you look at the causation standard, it need not be a searching inquiry, particularly in a case like this one where the timeline is very clear. And then you also raised some questions about the policy behind the bright line rule. And I just wanted to echo for the court the concern that was pointed out by our amici in that Smith's standard promotes an asymmetrical standard that places a thumb on the scale in favor of governmental defendants, allowing them to persist in defending in unconstitutional or otherwise unlawful policies or practices in situations where the court has already characterized them as such without financial consequence. Fee shifting, on the other hand, deters unconstitutional or unlawful conduct and motivates governmental actors to respond more promptly and evaluate the challenged statutes or ordinances with more gravity than they otherwise might from the beginning of the case. And then finally, with respect to the questions about en banc, obviously should this court decide that to find prevailing party status in this case would require an overturning of Smith because it has not been sufficiently undermined, then plaintiffs will gladly participate in that process. But as we've argued, we don't believe that's necessary in light of the new winter standard. Unless there are any more questions, I have nothing further.
All right, thank you. And thanks to all counsel for an excellent argument on this challenging issue. We appreciate it as a panel. Safe travels, although I know you're neither going very far. You may be seated. So we've been looking for you all. Where were you?
Sorry, Your Honor, we were waiting downstairs. I think we were waiting in the wrong place.
Clearly you were waiting in the wrong place, but we're ready now to get started in our second case, Morrow versus Navy Federal Credit Union. Ms. Gold for the appellant?
Yes, Your Honor, thank you. May I take off my mask?
Certainly. As long as, do you have your little thing on the microphone?
Yes.
Okay. The cover, I mean.
When a consumer shops online on what appears to be an American website with prices displayed in US dollars, she reasonably believes her transaction to be made in the United States. The question in this case is whether Navy Federal may nevertheless assess a foreign transaction fee on that purchase, and the answer turns on Navy Federal's contract language.
Counsel, I'm sorry, I hate to interrupt at the very beginning, but does the legal rule that you are arguing for turn on what the website looks like, whether the merchandise is being priced in US dollars? I mean, is any of that relevant to your legal argument?
The legal argument turns on the contract language, but I believe it's important background here
Okay.
in terms of consumers' experiences and how they view the contract and how they
That's fine. It was a genuine, so you are not saying that, for instance, in deciding how this contract language applies, it would matter whether the merchandise was advertised in US dollars or not?
No, Your Honor.
Okay.
Navy Federal's contract says it will only assess foreign transaction fees on point-of-sale transactions made in foreign countries. And in the briefs, the parties go back and forth on where these transactions should be legally considered made, with both parties citing the UCC and various choice of law principles. And while we believe the case law to be decisively in our favor on those issues, the question in this case is not actually about the UCC or about choice of law. It's about how a reasonable consumer would understand Navy Federal's contract language. And the answer—
And are you saying that the point of sale has to be at a retailer's physical location?
We believe the transactions are made in the United States because that's where the purchaser is located. In fact, the point of sale could be many different places. It could be where the merchant is located. It could be where the product is shipped from, which is what—
So do you agree that a transaction is made where the offer is accepted?
Yes, Your Honor, I
But
do.
you think the offer was accepted here in the United States by the purchaser rather than by the seller?
Absolutely, Your Honor.
So what about Virginia law that says otherwise?
Virginia Supreme Court law is clear on that issue. It's the Chang versus First Colonial Savings Bank case. It explains that when an advertisement is clear and definite and there's no negotiation, that advertisement is an offer.
What about J.B. Moore in that line of cases?
I believe that line of cases is referring to a commercial transaction in which there's an actual negotiation between the parties.
Counsel, you started by saying we want to know what a reasonable consumer would think this language means. Are you suggesting that to figure out what this language means, what a reasonable consumer should do is look up Virginia law, apply what you, even as you just said, it sounded like an incredibly fact-intensive and complicated analysis, and try to figure out where this contract was formed? I can't remember, or was it where the offer was accepted? I mean, how does that work?
Absolutely not, Your Honor. And I think that highlights the ambiguity of this language, that consumers—
So you do, I'm finished your answer. I'll follow up on the ambiguity thing. I didn't mean to cut you off. I want you to answer that question.
what we need to be evaluating this contract from is from the standpoint of a reasonable consumer. There are multiple interpretations for where a transaction should be made, and a consumer shouldn't necessarily be charged with knowledge of the UCC or choice of law principles. I'm simply saying that even if you were to look at those things, we are legally correct that these transactions are made in the United States and subject to the United States law. So when judges would apply United States law to this transaction, of course it's reasonable for a consumer to also think that these transactions are made in the United States. That has to be a reasonable interpretation.
So is your argument that it's ambiguous or it's unambiguous?
Certainly when we get to trial, we'll be arguing our interpretation is correct because we should be interpreting this ambiguous language against the drafter.
So right now you're saying it's ambiguous and the ambiguity is going to be resolved in your favor?
That's our position, yes, Your Honor. And in fact, we have Judge Gergel, that's precisely what Judge Gergel held in the Hart case when evaluating the exact same language, also under Virginia law, that the contract does not speak to with the clarity that Navy Federal ascribes to it.
Did you appeal the claim preclusion aspect of the district court's order?
We did not, Your Honor. Navy Federal here has actually put forward 3 different interpretations of where this transaction is made. They say it's where the merchant is located at one point. They say it's where the product is shipped from at another point. And they also say it's where payment is made. But in the world of global commerce, all 3 of those places could be entirely different, which highlights the ambiguity.
Oh, but counsel, what if there are multiple places where you could say this was made, that these transactions were made, including but not limited to the location of the merchant? Then wouldn't the contract language allow for charging the fees? Or is it your view that you're reading the contract to say, we'll charge the fees in one place only, and it will be where the transactions are made? And what if the transactions are made in several different places? Couldn't they then charge fees when the transaction was made at any one of those places?
No, Your Honor, it's the exact opposite. So Navy Federal has a duty to write a clear and unambiguous contract. If its contract is subject to multiple reasonable interpretations, in other words, if you can look at the word made and say that this transaction is reasonably made in the United States, I can understand that position. If you say the transaction is reasonably made where the merchant is located, or if you say the transaction is reasonably made where the product is shipped from, that means that the word made and that this contract is ambiguous, and at this stage, on the pleadings, at a motion to dismiss stage, the motion should be denied when it's subject to multiple competing interpretations and when the plaintiff's interpretation is reasonable.
Well, the transaction is made where the offer is accepted, right? We agreed on that earlier, I think. But then you were going to talk about Virginia law that's not J.B. Moore, but another. What case was it you were citing about advertising?
Chang versus First Colonial Savings Bank.
Is that? Okay, go ahead. Is it in your brief?
They brought up this point for the first time last week in the supplemental filing, and
Right.
we filed a response on Friday. and
Okay.
it's in our response on Friday.
All right, I saw that.
Yes. And in that case, it was a bank advertisement, and the consumer availed themselves of that advertisement, and the Virginia Supreme Court said that advertisement is clear and definite. There was no negotiation that happened here. So when the consumer accepted that offer, the contract was enforceable.
But again, I'm sorry. So if that's the standard we're applying to figure out what made mean, does that mean that Navy Federal has to, in every case, find out was there a negotiation over price before it decides whether or not to apply its fee?
No, Your Honor, because this is a form contract. It needs to have one uniform interpretation.
Right, so I don't understand how that can be the standard. The standard you just read is not going to have one uniform interpretation.
Well, certainly in these online purchases, we know how the internet works, that a consumer clicks buy, and certainly with the plaintiff's transactions, this is at chicme.com and freelancer.com, there was no negotiation, but in any transaction here, we would say the word made is fundamentally ambiguous. And according to a reasonable consumer, that these transactions are reasonably made in the United States.
I think I'm not being clear about my question. Every time you tell me about where the law is on where an offer is accepted, I start to sort of struggle with figuring out how, if we say that made means where the offer is accepted, how that is an even remotely manageable standard in this context. It may be that for many internet transactions, you can be pretty sure that there's no negotiation over price, but in many, many internet transactions, there is a negotiation over price. And how is Navy Federal supposed to figure out which is which? I mean, is it possible, is it a plausible reading of this contract that Navy Federal will, with respect to every internet transaction, conduct an inquiry into whether, under the governing choice of law and contract principles in Virginia, this one counts as the acceptance of an offer or not?
I think this highlights the ambiguity. The fact that this could be...
It doesn't, to me, seem to highlight ambiguity. It seems to me to foreclose an interpretation of the contract that would incorporate the legal standard you are describing, because it is literally impossible to apply, and no one could have possibly intended that.
The fact that we don't know where these transactions are made, that various facts would affect that analysis, that different judges would come to different conclusions, that this could be the topic of a law school exam, demonstrates that reasonable consumers shouldn't be expected to understand that they will be charged foreign transaction fees on these.
But your position is that what made means in this contract, a transaction is made where the offer was accepted. Is that your position?
Yes, Your Honor, and that the word made is inherently ambiguous, and that it is impossible to determine where...
It's not ambiguous, it's just incredibly hard to figure out. That doesn't make it ambiguous, it just makes it unlikely that anybody would have thought that is the meaning of this term, because in each case it will require a multi-factored analysis into the details of the transaction.
And it's their burden to write a contract so that consumers don't have to do the multi-factor analysis, so that consumers can look at the fee schedule and say, I'm going to be charged a fee on this purchase or I'm not. And the fact that you don't clearly know that from reading this contract, unlike many other banks' contracts, is fundamentally the problem.
But it seems like those are two arguments that are different. Made means where the contract is accepted is a position you could advance, and we could determine whether that's a reasonable standard. Maybe it's not, because it gets into legal stuff, and that's not how normal consumers think or would have understood things. But made is an ambiguous word is a different argument, it seems to me, based on what you're talking about. I mean, it just seems, maybe I'm not understanding your argument when it says on the one hand it's where it's accepted and on the other hand where it's ambiguous. It just seems those don't go together.
Our view is that the word made is ambiguous, and the fact that we can go back and forth with various legal principles, various hypotheticals, various factual scenarios proves that the term is itself ambiguous. This is one principle that supports the ambiguity.
Counsel, I want to switch from made to point of sale.
Yes.
And this is probably an unfair question because it's not in your briefs and I'm not holding it against you. But are you familiar with the concept or the discipline or interpretive tool of corpus linguistics?
I don't think I am, Your Honor, perhaps.
Okay, that's completely fine.
Again, with the term point of sale, both the dictionary definition of the term and the legal interpretation of the term have construed point of sale to mean a physical checkout counter and not necessarily to encompass an online transaction. And when you use these two words together, point of sale transactions made in foreign countries, you're reasonably promising to only assess fees when the account holder is physically swiping their card abroad.
Is that it seems to me your argument is better that there's an ambiguity when the focus is on the agreement document, the one-page agreement document says made in a foreign country. I kind of get the notion that maybe people can interpret that different ways. But when you say point of sale as part of the contract, which you allege to be the case, and I understand you argue that means the buyer must be physically present, but the focus there seems to be on the sale. It seems like point of sale, if cuts in favor of resolving any otherwise ambiguity in favor of the seller.
Well, I would just quote to you the Seventh Circuit in response. They asked this question.
Okay.
Where is the point of sale for an online purchase? The consumer's computer, the vendor's headquarters, the vendor's server, cyberspace generally? The Seventh Circuit didn't know the answer.
So you think that term's ambiguous too?
Exactly, and it highlights the ambiguity. Thank you, Your Honor.
All right, you have some time on rebuttal. All right, Mr. Gottlieb?
Thank you, Your Honors, and may it please the Court. Mike Gottlieb from Wilkie Farr on behalf of Navy Federal. I think the fundamental flaw in plaintiff's breach of contract theory is that their interpretation of the words made in and point of sale just can't be squared with what the Virginia Supreme Court has described as the, quote, holistic context of the words within the instrument. They have text arguments based on dictionary definitions, but none of them square with the context of the documents that explain what a transaction means. And this court doesn't need to decide where all online sales transactions are made in the abstract. You need to look at how those terms and phrases are used within the account documents. And I think there are three themes that run through the account documents that plaintiffs really don't have an effective answer to. The first is that the debit card agreement distinguishes between the initiation of a transaction and the completion of a transaction. It does so expressly, as in Section 3C's discussions of how transactions are authorized, and it does so impliedly, as in Section 4's acknowledgement that the card can only be used with the merchant who accepts it, and Section 5's reservation that Navy Federal can decline an authorization if it believes that an initiated transaction might be unlawful or pose compliance risks. That section by itself proves that in the context of the account documents, it just cannot be the case that a transaction is made wherever a consumer clicks purchase. And the reason for that is Navy Federal can say no. Navy Federal can decline to authorize that transaction, and then the merchant is never paid, a transaction is never completed. The second is that the agreements are also clear that a member can not only initiate or make a transaction, but also authorize a transaction to be made. Section 14 of the debit card disclosure recognizes that a member can challenge any transaction that, quote, you did not make or authorize. And that makes perfect sense, because these are agreements that talk about ATM transactions, where a consumer is physically placing a card into a machine, but also transactions that may occur at the point of sale, and we think we can talk about.
If I could interrupt you, counsel, I mean, it sounds like what you're arguing is maybe if you look at section or paragraph 7 in isolation, you could interpret that in different ways. You may not concede that, but maybe theoretically that could be true. But any ambiguity that results from looking at that in isolation is resolved by other parts of the debit card disclosure document. Is that what you're saying?
We don't think that the section is ambiguous, and we also don't think that you get to the point of determining ambiguity without considering the context of the document.
The context is in if the ambiguity or unambiguity is a line, it's above that line.
Right. So in other words, if you were to read Section 7 and think to yourself, transactions using your debit card made in a foreign country, it's not obvious to me where that takes place. You should, before concluding it's ambiguous, you should first look through the rest of the document to make a determination of how the term is being used elsewhere. And I think that one section that I hadn't gotten to that I think is very clear on this is that Section 8, which appears immediately under Section 7 in the debit card disclosure, makes clear that a member's account statement will identify the, quote, merchant where transactions are made. And that, I think, is very clear in illustrating how Navy Federal's account documents think about transactions. Transactions occur under these documents where the merchant is, and that's because it is the merchant that is reporting to Navy Federal where the transaction has taken place, the transaction amount, the currency in which the transaction takes place, which makes sense given that these are international service assessment fees. all of that is provided to Navy Federal by the merchant, not where the consumer is.
So can I ask you a question? Because it doesn't just say merchant, it refers to financial institution as well. And so one of my questions, a big question I have about this case, is I understand your argument. You're saying the transaction, when we look at the full context, it's clear that the transaction is not just the purchase, the original decision to make a purchase. It's this kind of complicated multi-step exchange of funds and debits and credits. And I think that seems right to me, but I don't understand how that means that complicated exchange of funds occurs like inside the merchant's store. If the transaction is the processing of credits and debits, couldn't that also be made where the consumer's account is debited or where the merchant's account is credited or on the server that sort of runs the numbers? And why is any of that in the back of the store?
We don't think it can under the context of the documents, in part because I think Section 8 is the only use of the phrase where transactions are made that makes clear it's where the merchant is, but also because throughout the account documents.
But I'm sorry, how does it make clear it's where the merchant is? It says it will identify the merchant, financial institution, or electronic terminal where the transactions are made. So why isn't you say it's on page 29 of your brief that the transaction is finalized when the merchant presents the transaction to Navy Federal for posting. So why doesn't, and then that transforms the hold into a credit. Why doesn't that happen at the financial institution where these accounts are being debited and credited?
Because the exchange of funds for goods, if it's a goods transaction, will happen at the location of the merchant. And otherwise, the merchant is the entity accepting the funds and shipping the goods. As just a logical matter, we think that's where it happens. But as a contextual matter, the reason that we think the account documents support that is because all of the action in the account documents that allow a service fee to be posted happen when the merchant transmits the data or posts the data to Navy Federal. So it is all of the action that determines when a fee can be assessed on a consumer for a transaction happens when the merchant acts. It happens when the merchant presents that information to Navy Federal. And so the merchant is the entity that is presenting the transaction, the exchange of goods to Navy Federal. Navy Federal then sends the money in order to effectuate that. What we know is it absolutely cannot be where the consumer is, and I think that's because both because of the distinction between initiation and completion, but also because they don't really have any answer to the hypothetical that we pose in our brief, both in the district court and here, of a consumer placing an order online for a product and the merchant coming back and saying, sorry, we're out, we don't have any of it. The merchant has to be able to fulfill the order or the transaction. And they argue in their brief that there is a completed contract that is formed as between the consumer and the merchant at the point that purchase is clicked. We think that's wrong as a matter of background contract law and UCC principles. We've submitted some authorities on that. But even leaving that aside, there's a distinction between a transaction and a contract for goods, right? So there's a lot of back and forth about the UCC and what the UCC means for sale of goods. We think we're right on the default principle there, but the complaint alleges not just a contract for the sale of goods, it has in it transactions that appear to be related for a contract for services. The freelancer.com website appears to be a services contract. So our point is that transactions can take many forms. The transaction that is relevant for purposes of the assessment of an international service assessment fee is a transaction that occurs when a merchant is essentially charging a Navy Federal customer for goods or services that are procured in a foreign country. And the reason and rationale for that is because oftentimes they'll be denominated in a foreign currency, and there are fees and transaction costs associated with that. And the only way that can ever be determined is by the location of the merchant that is making those determinations.
Since the Chang case was just raised a few days ago in this April 29th letter, do you have a response to opposing counsel's argument in that respect?
Sure. I think what I just said is in part a response to that, which is that entire debate is about what the UCC as incorporated into Virginia law means for the sale of goods. So first of all, we think there's a distinction between a contract for the sale of goods and a transaction. There's also a distinction between a contract for the sale of goods and a contract for services, which this complaint includes. even if you were to concede that they're right on the background legal principles, we don't think they are, but even if you were to concede it, they haven't alleged facts in their complaint that would support any of that, right? It's there, we're on a complaint with a motion to dismiss. The only allegations that they made in their complaint are that US-based consumers made online purchases from foreign-based merchants for these goods and services. There's no allegation that there was a definite advertisement. There's no allegation that there was an offer that was only made with specific quantity and price details that only one consumer could accept. Because remember, the background principle, going back to sort of Hornbook contract law, is that an advertisement isn't an offer, and the reason that an advertisement isn't an offer is because 1,000 consumers could claim that they accepted the offer on the spot, and then the merchant would have 1,000 or 999 breach of contract suits brought against them when they didn't have the good in stock. And so I guess the point is, even if you were persuaded that they've got the default rule right, they haven't alleged facts in their complaint that would support a finding of a breach of contract under that kind of a legal theory. And I think linking it back to some of the questions that Judge Harris was asking, it's not a reasonable theory for determining under these contract documents where a transaction would take place. We've made the logical point that they haven't alleged facts in their complaint that would suggest Navy Federal even knows where a consumer is when an individual consumer is on their computer and clicks purchase. But if you take their argument to its logical extreme, another hypothetical we give they don't have an answer to is it would mean, and this, I recognize the point of sale arguments answer this, but with respect to made in, their argument would mean that a US-based consumer goes on vacation, and while they're on vacation decides they're going to make some bill payments back, or they're traveling for business to a foreign country, they're going to make bill payments to a US-based merchant. By their logic, that is a transaction made in a foreign country that you can assess an ISAF on. Now, their answer to that is, well, that wouldn't be at the point of sale. And I should perhaps shift to that and address why we think that argument is incorrect.
Can I just, this case sort of drives me crazy, and I think the reason is that this contract uses this kind of location-specific language, right? Transactions made in a foreign country for something that is happening in cyberspace, I guess is what you would call it, just something that doesn't actually have a tangible physical location. And if you just ask somebody where an internet transaction takes place, I mean, it could be nowhere, it could be anywhere. And so it just seems like it's a term that doesn't have any kind of definite or meaningful content when you apply it to cyberspace. How is somebody just looking at this language supposed to know the answer to this question? Do you know what I'm saying? And your colleague cited that Seventh Circuit case where the court goes on. It could be anywhere. It could be where you're sitting at your computer. It could be at the store. It could be at the bank. It could be up in the cloud. Like, how is it? Where's the definite content for this kind of tangible location language when you're applying it in an intangible world?
So we think the best answer to that is in the context of the documents and all the provisions that we just talked through. Because I think if you try to describe it in the abstract, it becomes a very thorny legal question that will suddenly apply well beyond the dispute in this case as to where an online transaction might take place. That might have a different answer in tax law. It might have a different answer for personal jurisdiction law. It might have a different answer for the UCC sale of goods. Those questions are way bigger than the question of this case, which is how do you apply these terms within the context of these account agreements? And in the context of international/foreign transaction fees, which is the title of the fee being assessed here. It's clearly an international fee. It crosses international borders, and it's a foreign fee because the merchants are located in a foreign jurisdiction. And you get that context by working through all of the different provisions and understanding how the fees are assessed, in what order the transactions are placed on the account, and then in understanding the absurd results that would obtain if you followed the interpretation that the plaintiffs are reaching. I would also suggest, Judge Harris, that even if you look at, for example, they rely pretty heavily on the disclosures of other banks, and they argue that those banks show that there's a contractual ambiguity. We actually think those run in the other direction because every example that they have of a bank that charges international or foreign transaction fees charges them under these circumstances. They may use different language. Every bank uses different language in how they describe the disclosures, but they don't have a single example thinking about industry practice.
Yeah, but there's a difference. I mean, maybe I understand the argument, but it seems to me there's a difference in whether the custom or practice of financial institutions is to charge transaction fees like this, and whether made in a foreign country is commonly understood to include that. I mean, custom and usage is one thing you look at, and I guess that's your point, that in that interpretive tool. But that, don't you look at what financial institutions, what other financial institutions do, only back to my above the line, below the line, once you determine it's ambiguous?
We completely agree with that, Your Honor. I think you start with the text, and we have competing dictionary definitions, and we have an argument about how made in is used in the passive rather than the active voice that I think they don't have a good answer to. Then you use the context of the documents to inform that text. We think that ends the analysis because we think the context is quite clear. But even if, my point is, even if you were starting to think about how does a reasonable consumer in the abstract think about the meaning of these terms? How does what is an industry practice on the meaning of these terms? The only point I'm making is every other bank that charges foreign or international transaction fee charges them under these circumstances, and the only difference is how they word the disclosure.
Well, I want you to talk about point of sale, and I have the same question for you. If are familiar with the concept of corpus linguistics and have looked at that term with that doctrine or that interpretive tool in mind, you may not have. It's in your brief, and that's fine.
Yeah, we haven't looked at it in the context of the point of sale term in this brief or the interpretation of the contract language here. I think our arguments about the meaning of point of sale are, so first of all, point of sale does not appear in the debit card disclosure. It only appears in the schedule of fees. So beginning with that principle, we think the debit card disclosure is the relevant and operative agreement. It purports to be an agreement. We argued below that the fee schedule, which is the document that has the point of sale language in it, we argued that that was not, they hadn't sufficiently alleged that was a binding contract. They said they had sufficiently alleged it as a binding contract because it was incorporated by the terms of this third document, the MSC disclosure. And our point, and the argument that we have made, is if you are going to incorporate the fee schedule as a binding agreement based on the MSC disclosure, then you have to look at the language of the MSC disclosure all the way through it. And the MSC disclosure is quite clear that that point of sale is interpreted to mean debit card transactions.
So I'm just trying to make sure I understand your position, or what you're willing to concede or not concede we look at in terms of the contract. I understand you don't deny that the debit card disclosure that begins with this agreement is the contract.
Correct.
The statement of fees, the plaintiffs have alleged to be part of the contract, and you contested that below. So is it your position that that is not part of the contract that we should consider? And then if we do, we have to consider the third document you're talking about?
Right. We're saying that the schedule of fees, and this appears at page 22 of the joint appendix. If you look at it, it's a chart. It looks like this. And our position is that's not self-evidently a contract or agreement. It doesn't even have complete sentences in it. But if you're going to consider it a binding contract and agreement, the only reason it is because there is a provision in the MSC disclosure that incorporates it by reference. And if you look at that, our argument is it defines the term debit card transaction, also called point of sale. That definition that essentially says when we say point of sale, we're saying debit card transactions. When we say debit card transactions, we're saying point of sale. Makes a whole lot of sense contextually when you look at page 22 of the joint appendix at the chart, because it lists the only categories of fees that the document describes are current ATM and point of sale fees. So to believe their interpretation that this document is only designed to refer to brick and mortar in-store purchases, you would think that somewhere else within these account documents, somewhere, there would be a reference to a distinction about in-store purchases versus online transactions, that would be a kind of an important theme that would run through the account documents. It doesn't appear anywhere. There's nowhere in the account documents where there's a reference to online transactions at all. And the only reasonable reading of this in light of that is that definition, that point of sale and debit card are used interchangeably, it makes a whole lot of sense when you look at this document just on its face, even without considering the definition. But also,
yeah, another way of looking at that, I think, maybe I'm wrong here, but ATM transactions tend to be done in person, don't they? Can you do an ATM transaction when you're not at an ATM machine?
You could, so this is the active
I mean,
versus
that's
passive voice,
probably
right?
'cause
Like, you
I'm
could give your
too old
card
to know how to do
your
that.
spouse or your children or an agent of yours who could then make an ATM transaction on your behalf. You could authorize a person.
But you gotta go to a machine somewhere and stick it in, right?
Well, sure, but in the same way, you can use your debit card over the phone by calling in the number to a merchant. You could do that while you were abroad. You could do that at home. You could also enter that information into a computer, which you could do at home or in the store. You could even enter the information electronically while physically at the location of the store, given things like Apple Pay and iPhones and the ability to make transactions while you're walking around. And that's kind of the point. The point of sale is just the place where the sale happens. It is not, and that does not mean that you have to physically be present there at the moment that the sale or transaction takes place. And I think that that distinction runs not just through our documents and the cases, but all the cases that they cite about the other federal statutory scheme. It also makes sense in that context where you're talking about handing a physical print receipt over to a consumer at the point of sale. We've made that point in our brief. Is there no more questions?
All right, thank you. Ms. Gold, we'll hear from you again.
Yes. I'd like to address the word transaction because that's the word Navy Federal focuses on. To consumers, the transaction occurs when the consumer clicks buy at their computer. And if I use my debit card to pay for groceries in the checkout line and I buy milk and diapers, that transaction happens in the checkout line. It doesn't happen 3 or 4 days later when the grocery store goes to ask my bank to pay for that transaction. By that point, the milk is drunk, the diapers are used. This is the Roberts versus Capital One case from the Second Circuit. It evaluated similar language in the context of overdraft fees. It says reasonable consumers consider transactions to occur when they swipe their card, not when back-end bank operations are made. It's also demonstrated by Navy Federal's own contract, which says transactions using your debit card made in foreign countries will post to your account in US dollars. Posting is payment. Posting is the settlement of a debit card transaction. And so in this sentence, the transaction is made prior to posting. They have to be two separate points of time. Otherwise, you'd be reading the word will out of that sentence and rendering that word superfluous, which goes against contractual principles. To address a couple of their hypotheticals, they say, what happens if the merchant is sold out? Is that a transaction? We all know how the internet works. If you actually go to click buy, your card will be charged right away. If that product ends up being sold out, you'll get a refund. But the transaction still happened. It might be a canceled transaction, it might be a refunded transaction, but to the consumer, there was still a transaction. And to your point, Judge Harris, if the transaction could reasonably be construed as occurring in multiple places, if it could be construed as occurring in the consumer's home or where the merchant is located or in cyberspace or the cloud generally, then that highlights the ambiguity, and the motion to dismiss should have been properly denied if there are multiple reasonable interpretations for where this transaction could have been made. They also try to kind of disclaim their fee schedule as not a contract, which is very odd for a bank or credit union to do because it's the only place that actually lists how much they're going to charge. So by that logic, they're not bound by the fees that they list on there, and they could charge whatever they wanted, even if it's not listed in the fee schedule, which just as a practical matter is not how banking works. It's very clearly a contractual document, and I would argue the most important contractual document because it's the one that consumers are handed as the summary of fees that they're going to be assessed. It's supposed to be a clear, easily digestible listing of fees. And I think their last hypothetical has to do with what happens if a consumer purchases a transaction while they're away somewhere else located abroad. First of all, the fact that we can come up with so many hypotheticals and what's supposed to happen, again, highlights the ambiguity. But I would go back to our interpretation of this contract, which is a reasonable interpretation, is that you can only charge this fee when the consumer is located abroad and physically standing in a foreign country, which is a fact that discovery will reveal Navy Federal does know. They know when the card is with the purchaser and when the card is not with the purchaser. So this is an entirely enforceable interpretation of the contract, and it is one that other banks and credit unions will use, but again, that's a fact that we'll get into after discovery in this case. Unless you have any further
Okay.
questions.
All right. No, thank you. Thank you both for your arguments. You clearly each know your cases very well, and we appreciate that. Thank you, Ms. Gold, for traveling across the country to be here to argue today, and safe travels, Mr. Gottlieb, back up I-95. That can be treacherous. All right, we're ready to hear argument in our third case, Weber versus Department of Veterans Affairs. Mr. Day, whenever you're ready.
Thank you, Your Honor. Good morning. May it please the court. With the court's permission, may I remove my mask?
You may. When you're arguing, you may remove your mask.
Thank you, Your Honor. The question in this case is not what the VA could have done, it's what they would have done absent Dr. Weber's protected activity. One of the particular points that the judge below in the VA in its arguments makes is that appellant Dr. Susan Weber was there during her probationary period. As a matter of logic and as a matter of law, the probationary period is irrelevant. And I would particularly direct your attention to Whitmore at 680 F. 3rd, 1374. The strength of the evidence supporting those allegations does not turn on the procedural protections to which the appellant was entitled. This is consistent with the overwhelmingly important emphasis that both the legislative branch has repeatedly placed on the protection of whistleblowers, and in fact, that the Secretary of Veterans Affairs himself emphasized at the town hall meeting.
When was the first protected disclosure, in your view?
The first protected disclosures began very early in Dr. Weber's tenure. As I believe the record reflects, she repeatedly addressed concerns to both.
Right, when was, can you put a actual time frame on very early? Was it June 2017?
Your Honor, I would say it was before June 2017, because June 2017 actual.
Because concerns or issues about her work began to be documented in February to April of 2017. Did her protected activity occur before or after that, just the first?
I believe it occurred simultaneously, Your Honor, and in fact, however, it's important to note that both Michelle Cook and Dr. Mann admitted on the stand that in fact they did not document the alleged complaints against Dr. Weber. This is remarkable, indeed extraordinary in the federal government.
Right, they didn't document all of them for sure, but they did document some, just not everything that they say occurred.
Well, Your Honor,
correct?
No, I would argue that.
I mean, they did document some. I'm actually sort of helping you, trying to help
Yes,
you here.
sir.
They did document some, but not enough, in your view.
Absolutely not enough, Your Honor. And in particular, if you go back to Whitmore, where the appellant prevailed, the appellant in that case actually threatened to punch his supervisor. That seems to be extreme misconduct, and that's only one instance of misconduct. It's commonly understood that whistleblowers, almost by definition, are not, quote, team players. If they were team players, they would not be speaking out about problems in the workplace.
So I'm a little confused by that. I mean, I guess I understand what you're saying, but are you saying that if the evidence were to support a decision to terminate or not renew employment or whatever, based on evidence that an employee was not a team player, and that was, there was compelling evidence of that, are you saying that the whistleblower protection would just obviate that? That's not a valid reason?
I'm not saying exactly that, Your Honor, because I would add that in this case, and also in cases such as Whitmore, the protected activity and the alleged not cooperating or lack of being a team player were the same. In Whitmore, the appellant was directly challenging his supervisor's record keeping and leave. In this case,
It's different, right?
sorry?
It's different here.
No, I don't think so, Your Honor, because
You're saying that the at least from the VA's perspective, the team player comment is all tied to the protected activity?
I would say overwhelmingly tied to the protected activity. The one potential exception here, and the one that allegedly kicked off the action, was the incident with, or the alleged incident with Christy Ann Cook. In that instance, the judge failed, number one, to do a thorough analysis of the credibility of Ms. Cook, or the likelihood that she would be believed. And in fact, the record evidence is that, her story that in fear of her life, she crossed the parking lot discussing matters with Dr. Weber when she had a cell phone. She got out of her car. She walked across the parking lot. She walked up to her office. She went into her office. She never cried for help. She never called for help. She wouldn't got out of the car. That all this time she was in fear of her life. That is totally uncredible.
Well, we can't make credibility determinations, right?
Your Honor, I would say in general, credibility determinations are not reviewable. However, nevertheless, I would argue that a failure on the part of the judge to apply relevant criteria under the Hillen Act and a failure to consider the evidence that is contradictory or inconsistent with the testimony, that in fact would be reviewable despite the general principle that demeanor evidence is unreviewable. Demeanor evidence.
Could I?
Yes, sir.
I'm just trying to kind of back up and unrelated to the facts. I want to make sure we're as clear as we can be on our standard of review here. We have this combination of the initial obligation on the VA to prove that they would have terminated your client regardless of the protected activity by clear and convincing evidence. And then we review that based for substantial evidence. So I'm familiar, I think, with the Miller case from the Federal Circuit that kind of talks about them as in a way that doesn't clarify a whole lot other than saying it just means maybe more than there would be if it was not clear and convincing. What's your position on how do we do that? How do we look at substantial evidence in the context of an initial burden that's clear and convincing?
Well, Your Honor, first of all, I do believe you need to analyze what the evidence is that clear and convincing was met. We submit that the evidence is gossamer thin in this case.
Is what?
Gossamer thin.
Okay.
A thread that the clear and convincing standard was met. It just doesn't pass the laugh test that they had the evidence or that Dr. Mann was not motivated. And in fact, the judge below flips the standard for car factor 3 by suggesting that it's up to the appellant to prove that there were no comparators and that other people with misconduct were not fired.
Can I just ask you to address, and I do fully understand who has what burden at this stage, but the department is coming in and saying, this is a probationary employee and she was terminated because it was a bad fit, in part because she allegedly tried to run over her coworker in the parking lot, and then the Foley report documented some substantial workplace issues. So what is the best record evidence, in your view, that actually she was terminated because of her disclosures at the town hall and at the Blackburn meeting? And I understand who has the burden here, but I'm just asking you to address, as a matter of sort of like common sense, what is the record evidence that that's why she was terminated?
Your Honor, with your permission, may I just very briefly complete my answers?
I didn't understand. I was cutting you off, of course.
Not at all, Your Honor.
Did he answer your question to your satisfaction, Judge Quattlebaum?
I'm fine. So
Let's answer Judge Harris's question and then come back to Judge
Okay.
Quattlebaum.
All right, well, Your Honors, I certainly want to comply. So, Your Honor, as I understand it, just come back to, you're asking for our best evidence that in fact it was the protected activity. Looking back to the the car factors and what, in fact, the agency is required to prove to show clear and convincing evidence. We are not proving.
I know. I
Okay.
tried to be really clear about this. I do understand you don't have, who has what burden.
Yes, Your Honor.
But I am just really struggling with this question because they have attempted to meet their burden by saying, look, she allegedly tried to run over her coworker. We had to have a whole investigation. We did have that investigation, and it surfaced at least some substantial workplace issues regarding your client, and that is why she was terminated. And I guess I'm just asking you, as a matter of like the facts in this record and as a matter of common sense, is there some evidence that no, that's not what happened?
Yes, Your Honor.
Okay, great.
Clearly there is.
Wonderful.
First of all, to go back to Dr. Foley's report and Dr. Foley's conclusions, Dr. Foley did not recommend Dr. Weber's termination. The only thing Dr. Weber recommended was that the two of them not be in the same supervisory line. The criticisms of Dr. Weber were mostly on the line that she was too concerned with matters of clinical competence. Particularly someone who's brought in when a reformer, it seems hard to believe that that really is something that should be brought against her. There was no action taken on all these alleged problems until Ms. Cook surfaced her concerns. It's noteworthy that while Dr. Foley did make a mention of Ms. Cook's competence, it was competence to do case planning. It was administrative functions. He did not say she was competent to do
Can I
that.
back you up a second? The thing you said before that was that no action was taken until after the protected disclosures, right? So there's like a timing thing you're relying on?
Yes, sure.
Okay, so this is, I will say, this is one of the things that troubles me about this case. It is true that these actions came close in time to the disclosures, but they did also come even closer in time to sort of what you might think of as an intervening event, the incident in the parking lot and then the Foley report. And so I'm having, to me, that sort of complicates the picture, and I don't know whether that falls under prima facie case or rebuttal, but while it is true that there is a proximity in time between the disclosures and the termination, there is also a proximity in time between the alleged episode in the parking lot and then the Foley report and the termination. So I don't know how much weight I can put on the temporal proximity here.
And I think that that particularly goes to the question of motivation. There's a clear contradiction between the fact that the judge finds it as a contributing factor, and then he says, oh, well, it's not really a motivating factor. And the way he tries to elide that is he cites this broad standard and ignores the fact that this was criticism of man that was personal. It was also professional to the reputation of his department and his agency. Dr. Weber, before this happens, she stands up in a town hall meeting. She says, Mr. Secretary, should we be bolder about our criticism? And then afterward, she meets, with man's knowledge, with a number two in the department. She arranges with him at that time to go with her colleague to talk to the number two in the department. The judge credits Dr. Weber's testimony and corroborated by Dr. Harrison's that they just ripped Dr. Mann in front of the head of the department.
Counsel, I'm sorry, were you suggesting that there's like an inconsistency between saying on the one hand you've made your prima facie case on causation, but on the other hand we're not finding much evidence of motivation?
I am saying that, Your Honor, and I'm saying that the judge...
But isn't that sort of implied by the, isn't that not implicit, intrinsic to the car factors? You're not arguing that we should not apply the car factors, are you?
No, I'm not arguing they should not apply the car factors.
But don't the car factors sort of specifically say that even having found causation, there should now be a separate inquiry into the likelihood that this was the motivation?
And I'm saying that the car inquiry independently is fully met.
Okay.
They don't at all carry their burden on car factor 3. their evidence is completely insufficient when it comes to documentation, when it comes to the accounts they supposedly relied on, when it comes to the inconsistency in their disciplinary action, when it comes to their denial of any motivating factor on man's part, to their complete denial of any knowledge of past history of misconduct on his part, on past history of mendacity on his part. And there is a credibility finding from the judge when he says that Dr. Mann does not seriously rebut the testimony, the rather strong testimony of a unique meeting, the second in command of the entire department. And Mann doesn't remember what happened, and there's credible testimony that the judge credits that they went through an exhaustive list of problems with his department. That combination of reflections on him personally, on the way he runs his office, which is a danger, reckless to veterans. That's the number two of the department. That's got to be a motivating factor. And the fact that he can smile through it should not allow this court to allow any sociopath that walks in to go free on motivation. I see my time is up, Your Honor. If you have any further questions, I'm happy.
We don't, but you have time in rebuttal. Thank you.
Thank you, Your Honor.
All right, Mr. Yale.
Thank you, Your Honor, and may it please the court. I'd like to first address CAR Factor 1. So, as Your Honors were pointing to, the government here, the VA, relied heavily on this investigation report. The investigation report was done by Dr. Foley, who there's been no allegation that he was biased. There was this intervening event, which was this incident in the parking lot. There were allegations of a...
So is Dr. Fuller's report the best evidence of the reason for her termination?
Yes, Your Honor. We think it's the investigation report is central to the basis for the termination. Obviously, in this case, petitioners argued that there was not a finding that there was a hostile work environment.
Right.
But if you actually, when you review the report, there are also negative findings about...
Well, there are positive findings about Dr. Weber as well that aren't reflected in the, at least in the board's consideration.
Well, respectfully, I think that the board considered all of the findings because the board is incorporating the entire report. And so, for example, the board did point out that findings unhelpful to the government, for the government's case, for example, that Ms. Cook was, quote, emotionally reactive, that the hostile work environment claim was not substantiated. But there are also findings within that report that are certainly negative. It stated that there are instances of, quote, unprofessional conduct by both Ms. Cook and Dr. Weber. And the conclusion of the report as well is that Dr. Weber, who's a supervisor, cannot even work in the lines of authority with a subordinate. And we're talking about during this initial probationary period, we already have a situation where there's a supervisor clashing with subordinates. It's not the only incident that was identified in the report. And so we think that based upon that independent report, that that's sufficient for the board to have found that the government met its burden by clear and convincing evidence. Now here, as the appellate court, you're obviously tasked with determining whether or not there's substantial evidence for that, for those findings.
Didn't the board rely on the fact that Dr. Weber was in her probationary period during which the agency may evaluate her overall performance and whether or not she was a proper fit? Was the language the board used and the language you use in your briefing?
That's correct, Your Honor. And that, the fitness, I mean, that's coming from the probationary regulations. That's coming from Dr. Mann's testimony that the removal during the probationary period was not just solely based upon this report, because the report was not commissioned to determine whether or not this employee should be removed or not. It was commissioned for a different purpose. But when faced with this report, it's certainly well within the agency's purview to determine whether or not this supervisor should continue in employment when this is the probationary period. So Dr. Mann certainly testified that based upon this report and other conversations he had, that he made the determination that Dr. Weber was not a proper fit.
Is that why she was terminated, because she wasn't a proper fit?
Well, I think it's a combination. I mean, I think it's it's clearly, at least in part, based upon what has been deemed misconduct. And so the report says, it specifically says instances of unprofessional conduct. But with respect to Dr. Mann's testimony, he's certainly identifying the fact that we have a supervisor who's clashing with subordinates, also clashing with staff. And the agency, especially during this probationary period, is well within its rights to determine whether or not a supervisor is the proper fit. And when you look at the report that we're talking about, I mean, this is an intervening incident that has nothing to do with, these disclosures that have been highlighted, for example, with respect to the town hall meeting or the later meeting with Mr. Blackburn.
It almost sounds like, in listening to your argument, that individuals who are still within the probationary period are not protected from retaliation for any protected activity they may engage in, because the agency could just say, well, not a proper fit, and that's very difficult to challenge.
Respectfully, that's not what we're saying, Your Honor.
That's good.
Just to make it perfectly clear, although the employee in the probationary period does not have certain due process rights, if, for example, the agency violates the law, they violate the Whistleblower Protection Act, they violate USERRA. I mean, those have to be analyzed based upon the frameworks. But what we are saying here is that you certainly have to look at the strength of the evidence under CAR Factor 1. And part of the evidence there is colored by that this is the probationary period, and that something like fitness to be a supervisor, that is something that is addressed by the agency in that probationary period. And so that comes into play with respect to CAR Factor 1. Now, the ultimate standard has to be, and is set by statute, that there has to be clear and convincing evidence that the agency would have taken the same personnel action in the absence of the protected disclosures. So we certainly agree with the overall standard here. But with respect to CAR Factor 1, we submit that the probationary period is a factor to be considered. But again, as Dr. Mann testified, a lot of the basis here is this independent investigation report.
Counsel, can I redirect you from CAR Factor 1 to CAR Factor 3? And with respect to that factor, what did the VA do to meet its burden under CAR Factor 3?
What specifically did they do? Mm-hmm. Respectfully, we don't think that that's in the record. I don't think that there was testimony, at least, that there were, for example, discovery requests or anything along those lines.
But don't you, and there may be nothing in the record on that point. So I'm trying to figure out how this works with you having the burden of proof. And is nothing in the record good for you or bad for you? If you have the burden of proof, it would seem to be bad. If it's, So that's what I'm trying to get at.
I understand your question. If you look at the Federal Circuit precedent that has directly addressed this question, if we're looking at cases like Carr itself, Whitmore, what the Federal Circuit has held is that if there's no evidence on Carr Factor 3, it can't favor the government. But it can certainly be a wash. And setting aside the personnel action, which was the reassignment, which I don't think is necessarily central here, but with respect to the removal itself, here the board found that there was no evidence of comparators here. And so therefore, it was a wash.
But that gives you, I mean, if in any other case, if you have the burden of proof and you don't produce evidence, yeah, you lose. So and I don't think you lose the case, but you at least necessarily, but at least for Carr Factor 3, how can that cut in favor? And you may, nothing says you have to get all three. I don't think we look at all the three factors and decide. But on that factor alone, doesn't the fact that you apparently didn't, not you personally, but the VA didn't put in evidence on that issue, doesn't that cut against the government on Carr Factor 3?
Respectfully, Your Honor, we don't think it cuts against the government based on the Federal Circuit precedent, but also I think just to take a step back, when you're looking at the Carr factors, the overall standard is clear and convincing evidence to take the same action. But the Carr factors are essentially guideposts. Right. So the agency does not have, the agency is not under a burden to establish each and every Carr factor by clear and convincing evidence. So the Carr Factor 3 was really established and really identified initially by the board and then accepted by Carr for the situation where there may be strong, for example, this is just a hypothetical, strong evidence under Carr Factor 1 and no evidence of motivation. But then when you look at it, for example, if you had somebody who was being charged with misconduct for falsifying timesheets or something along the lines. So there may be a lot of evidence with respect to Carr Factor 1, but then it turns out there's also evidence, and the agency, either it was pointed out by the petitioner or the agency had the evidence that there were 50 employees and 49 of them, did not receive any discipline there. And so that's really what Carr Factor 3 is getting at when you have similarly situated individuals who were not treated the same when they were not whistleblowers. And here, there's really no evidence here in the record, certainly not pointed to by petitioner, that there are similarly situated individuals. In the opening brief, the petitioner even acknowledges that it would be a, quote, stretch for either Dr. Mann or Ms. Cook to be deemed comparators. And that's certainly supported by the record because, for example, Ms. Cook, she's not a probationary employee. She was not alleged to have committed a hostile work environment. Similarly, with respect to Dr. Mann, I mean, he's a higher level supervisor, and he's not a probationary employee. So the record just doesn't reflect that there's any evidence there. And if there's no evidence there, it shouldn't cut against the agency. It should just be a wash, because what that's really getting at is the situation where there are these other individuals who are not being similarly situated, similarly treated, and that evidence is available.
Can I ask you a question about that's? I'm sorry. Did you finish answering Judge Quattlebaum's question?
Oh, I'm finished.
Great. I'm sorry. I just wanted to make sure I wasn't cutting anyone off. So I understand what you were saying about comparators and about Carr Factor 3, but I do want to go back to Ms. Cook, and I take part of your colleague's argument to be, look, what you have is this Foley report that basically finds sort of, I don't call it like a toxic workplace dispute between two people who are both at least a little bit at fault. And what it recommends is, look, these two people can't work together anymore. They're both behaving unprofessionally, and you need to separate them. And so I take part of their argument to be and then you fire one of them and not the other. And so there has to be something going on here besides just the incident and the Foley report, and we think that something is the disclosures. What is your answer to sort of, well, what is the something that distinguishes the two? How do we explain the differential treatment of these two women?
Well, I think even under CAR Factor 3, a big differentiation here is that Dr. Weber was a supervisor, and supervisors are held to a higher standard. That's littered throughout MSPB case law, both certainly at the federal circuit, and that makes sense. Supervisors are held to a higher standard, and we think that just on its face differentiates that.
Okay, so it's not the probationary period, because I could also imagine the argument being, look, two people can't get along, we're gonna have to let one of them go. I guess it's the one on her probationary period.
Well, I think the probationary period, we've obviously identified that that's a factor in what was going on here. I do think, and I'd have to sort of refresh my recollection on it, Ms. Cook had also not been, I don't think she was in her probationary period, but she also had not been around for a long period of time. But what we're talking about here is the personnel action with respect to this supervisor, and during that probationary period, should she continue to be supervising individuals.
And the record is somewhat thin on issues there may have been with Dr. Weber before, but there is some indication, isn't there, that there were issues percolating with her early on prior to, and I know it's still close in time, but prior to her alleged protected activity?
That's correct, Your Honor. And Michelle Cook testified to that. There were also notes within the record. For example, Michelle Cook at Appendix 1183 was discussing issues with another doctor that Dr. Weber had. Appendix 1191, clashing with other program managers. And so that was in the period before. Certainly we're not, we haven't asserted that there was a large volume of notes or something in the record with respect to those particular interactions. But one point on that is during that probationary period, there's not, it's not the same. For example, if it was outside the probationary period, managers would have to, if they're going to remove somebody for performance, you'd often have to put them on a performance plan and document that, and there's a lot of steps that need to be taken. And so we think the record is reflective of the fact that it was not during that particular period of time.
You are not appealing, are you, the board's finding that the prima facie case was established, and in particular that there's a prima facie case of contributing factor causation here?
Correct, Your Honor. We are not appealing that. And if there's, I think I've addressed sort of the points from that I wanted to address. If there's any further questions, otherwise we would ask that the court affirm the decision of the board.
All right, thank you. Mr. Day, you have a couple minutes reserved for rebuttal.
Thank you very much, Your Honor. I have 3 points in particular. One is Christiane Cook, as documented in the Foley report, she was not merely reactive, in quotes, toward veterans. She was abusive to veterans returned from combat with PTSD in therapy sessions. The VA takes patient abuse very, very seriously, as they should. And yet, Christiane Cook was not fired, she was not suspended, she was not reprimanded, she was not counseled, She was merely moved to another position in which she was not having contact with veterans. That is a massive difference. Number two, Dr. Weber, she was brought in to deal with a department that at the very least had severe problems, if not being crisis. She described all kinds of issues with unlicensed providers, not enough providers. She was there to reform that place. There's always going to be some friction between a supervisor who comes in to bring change and employees, and in particular, employees like Christy Ann Cook, who are not just reactive, who are massively incompetent. And yet Dr. Weber, the record shows, from Dr. Weber's perspective at least, that she was trying to help Christy Ann Cook as well as ensure good clinical care. Finally, Dr. Weber was only, quote, not a good fit, or at least in terms of any action the VA took, until after that town hall meeting when she pops up and addresses the secretary about problems and then talks to the second in charge of the VA afterwards with the deciding official's knowledge. I see I'm out of time, Your Honor. If there are any further questions, I'm happy to address them. Otherwise, I'm concluding.
All right. We thank you both for your arguments in this interesting case. All right, we'll hear arguments in the fourth case now. Thank you.
And please remove your microphone covers.
I regret that one consequence of the pandemic is that we do not get to shake your hand.
Yes, we. Okay, are you all ready? Oh, we're waiting for you. All right, then, we're ready to hear argument in our last case of the morning, Sowash versus Marshalls. Mr. Grimes, whenever you're ready.
Yes, thank you. May it please the court, good morning. And yes, Terry Grimes here for plaintiff appellant Summer Sowash in this appeal. Very good to be here. I appreciate the opportunity for oral argument in this case. This case comes to you on summary judgment from the Western District of Virginia. The primary issue in this appeal is whether a jury could find that the harassment in question was objectively severe or pervasive, that being one half of the third element of a hostile work environment claim. The answer to that question is unequivocally yes. Let's just dive in and start with the cumulative impact of repeated touching, which is one of the totality of the circumstances factors under Harris versus Texas forklift systems. When you and I come to work, we try to work on our cases. You may write opinions, I try cases, whatever. But when the summer so washes of the world come to work, they ask, is he going to touch me again today? And that colors every aspect of their working world. Each touch is worse than the one before. And that's what happened in this case. The cumulative impact of this touching was debilitating to her. And I submit to you that any reasonable woman could have felt exactly the same way. It's not so much about sexual desire in this case, but it's about power and control and the need to dominate subordinate women in the workplace. And a jury could easily so find. Just look at it another way. There's not a woman inside this courtroom, from the bench to the law clerk to the courtroom deputies to the women in the audience, virtual and real, who would tolerate for 1 minute some man coming up to them at work, holding them close with one arm to his body, and running his finger up and down their other arm every day for up to a minute at a time for several months. Very few women would tolerate that.
Counsel,
Yes,
can I ask you, does your argument on pervasiveness, and I guess severity too, does it turn on this happening every day or near daily? Because I understood the district court to find something like more like between 10 and 20 times over a period of 3 months. Does that matter to your argument?
The frequency matters.
Yeah.
Frequency matters.
So is it important to your argument that it was what you said every day?
I didn't say every day.
Oh, I'm sorry, I thought you did.
It is continuous almost every day.
Okay.
Almost.
Okay, is it important that the almost everyday part is important to your argument?
I don't know that it's not a mathematically precise test. What the plaintiff said had happened more than 10 times, and whether that was metaphorical or literal, the fact is that more than 10, the numbers run from 11 to infinity. So the most that we can say from the evidence is that somewhere between 11 and infinity, and that was continuous nearly every day between.
But I thought she couldn't remember whether it was more than 20.
She said she couldn't remember, yes.
Okay.
In the deposition. And
So doesn't that rule out infinity? No?
well, it probably rules out infinity, Your Honor, it does. But more than 10 is certainly somewhere between more than 11. Now, whether it's 11 or 20 or 30 or 40, it's not a mathematical precision.
But I'm sorry, but if she can't remember, I really don't, this was a genuine question about how much emphasis you want us to put on sort of the near daily part. Because if she can't remember if it happened more than 20 times, it's not obvious to me that a reasonable jury could find that it did happen more than 20 times.
I disagree because what she said is a continuous, nearly every day. In depositions, that's what happened. The defense, was it 100? Was it 75? Was it 37? Was it 42? But mathematical precision is not the test. The test is the impact on her and a reasonable woman.
I have a different question. So she also testified at her deposition that the unwanted touching stopped in June 2018 after she spoke with Joe Taylor, but that the remarks and bullying got worse. What specifically does appellant contend Appley or Hughes said to her after June 2018?
He kept saying things to her like, oops, don't report me again. Oops, did you report me again? And things of that nature. Yeah.
Where is that in the record then after June 2018?
I can't specifically point after June of 2018, but that's what she said. The bullying got worse.
So that's the bullying, don't report me again?
Well, there's more to it than that. There's more to it. Yes, there's more to it. He would comment on her clothing, make compliments, but these were not compliments. These were not genuine compliments. This is what he was saying. He was saying, look, I'm still here. I know if you reported me to management over and over, I'm not going anywhere. Marshall's is not going to do anything. Because
Wait, are you saying he actually said that, or that's how appellant perceived what he was doing when he complimented her?
That's how she perceived it. And that's how it was viewed by Lynn Terrell as well. She says specifically in her declaration, these were not compliments. This was him exercising his power and control over her, telling her, I'm not here, I'm not going anywhere, I know Marshall's is not going to do anything. And that's after she complained to 6 levels of management. So, but that really goes more to the 4th element, I think, to the 3rd element, which is not at issue in this appeal. But the point is, with respect to the objectively severe pervasive, there are not many women who would tolerate this sort of touching for months on end, whether it's 10 or 20 or 30 or whatever it is, for months on end, nor should they have to, just to work and earn a living. They should not be faced with this Hobson's choice. She was asked, why didn't you do something? Why didn't you smack him or something? And she said, I needed my job. I needed to work and make a living. But when you remember when she complained, she was told, quote, that was too bad. You're going to have to be scheduled to work with him, David Hughes. That's what she was told. A jury may find that any reasonable woman would find that offensive. As I've said on brief and simply put, women are not property. They have a right to work. They have a right to be left alone. They're not to be touched and prodded like cattle at the whim of whoever they're working with. They have a right to be treated with dignity and respect. And that'd be true if there's not a single case on point, but I've cited to you Zetwick versus City of Yolo, very similar to this case, King versus McMillan, the Beardsley case, and so forth. And you have to bear in mind that this process, the depositions, for example, were brutal. They were brutal to the point they had to be adjourned so the plaintiff could throw up. And marshals at one time asked plaintiff's mother, is it true that Ms. Sowash was raped once and only once? This process is brutal for women who have to go through this.
Counsel, can I ask you a question? So we're reviewing this district court decision, and the district court, in applying the severe and pervasive standard, thought that what the record, the facts that could be sort of had been established on this record, the facts that he would consider, that the district court would consider, were the one-armed hugs and touching of the arm at least 10 times, the welcome back hug and kiss on the cheek, and then the compliment about looking good in yellow. Is it your position that there were other facts that ought to have been considered, or is it your position that on those facts, the district court came to the wrong legal conclusion, or maybe both?
Both,
Okay.
because there were, under Ziske versus Mineta, the court considered other harassment in the workplace, the chasing the young woman down the...
But only if the plaintiff knows about it, right?
Yes, there's some case law that says only if the plaintiff knows about it, but she certainly knew about the references to the I forget the name of that movie, the Shades of Grey movie.
And where is that in the record that they were aware, that the plaintiff was aware of that?
Okay, I can't point that to you as I look here.
Okay, but you believe, but you do believe that there are other facts where the record will show the plaintiff was aware of them?
Well, certainly she was aware of what was going on with Christy Thomason. Remember, that those are the two women that David Hughes reserved his very worst for. It was Summer Sowash and Christy Thomason. Remember, that's how all this got started. Back in February of 2018, she was in a meeting with David Hughes and saying, look, I hear this is going on about Christy Thomason. If you don't tell me the truth, you and I are going to... He uttered some profanity to her. And that's when all the touching started. That's when the touching started. So from the very beginning, it was about power and control and domination and over her. And throughout that time, as I've said, he would say things like, oops, don't report me again, as if it were all a joke. And she described a question. How did he sexually harass you? Answer, he would touch me, he would hug me, he kissed me, all the comments that he's made about my appearance, and it was continuous almost every day. And I submit to you very simply that there's no question that the harassment was subjectively severe or pervasive. No question about that. The court made that finding or assumption. It reduced her to tears in the workplace to the point she reported it through 6 levels of management. And we simply submit to you that the jury could find that a reasonable woman would have felt the same way. There are 3 other issues in the appeal. I may run out of time on them, but I do want to address them quickly with the time that I have. And that is, first, the Virginia State common law claim for assault and battery. Similarly, for reasons stated, a jury could find that the harassment was objectively severe or pervasive, assuming, for sake of argument, that there is an objective versus subjective dichotomy under Virginia common law, which we take issue with. The only case cited by the court on brief below was this Ballas versus Huntington Ingalls Industries, and that's distinguishable. That case involved a gift of a plate of Christmas cookies to a man and a hug by him. That's all that case involved. That's nothing like the facts of the case at bar. The defense raises the because of sex argument. That's a red herring. I can dispose of that argument in one sentence. It's simply undisputed that Hughes treated Sowash and other women, like Christy Thomason, categorically different from the way he treated men at work.
How is...
So, Marshall's concedes on brief that there's no reason why a homosexual man could not sexually harass a woman at work. And then finally, we have the Lynn Tyrell affidavit, another red herring. First, Marshall's never moved to strike that affidavit below, which they should have done. Therefore, this court should not entertain the question on appeal in an appellate case. And next, Rule 56 not only permits the filing of affidavits, it requires them so the court consider all the evidence before it on summary judgment. Rule 47 says that has to be filed at least one day before the hearing, which it was in this case. It's not hearsay. Tyrell's a manager. She reported what she saw and heard, and she's charged with reporting sex harassment up the chain. That's exactly what she did. And as stated on brief, it would have been reversible error for the district court to fail to consider the affidavit anyway. So that's just a red herring. So in conclusion, we ask this court to reverse the judgment of the district court and remand this case for trial. This case has nothing to do with the line of cases that concern accidental touching in an elevator or some such. That's not actionable. But here we have purposeful touching for the purpose of exercising power and control over a woman. That's what he did for many months. So thank you very much. I'll stand down.
All right, thank you, Mr. Grimes. Mr. Baldwin, we'll hear from you.
Thank you, Your Honor. Ray Baldwin on behalf of David Hughes and Marshall. May it please the court. Welcome back hug and a peck on the cheek is not sexual harassment, and it's not assault, nor is it battery. Ms. Sowash's written statement of the welcome back hug confirms this point. She says that after she came back from a medical procedure, Mr. Hughes hugged her and kissed her on the cheek and welcomed her back. Her coworker, Vivian Menendez, the same thing in her statement. She says that Mr. Hughes hugged her and gave her, quote, the appearance of a peck, close quote, and welcomed her back and indicated he was glad she was doing better. This conduct does not meet the high standard required to demonstrate severe or pervasive harassment. In determining whether harassment is in fact severe or pervasive, as the court knows.
Well, what about, I wonder if I could ask you to address sort of what your colleague was mostly talking about today, not the welcome back hug and kiss, but the continuous, the one-armed hugs and the touching of the arm.
Absolutely, Your Honor. This assertion that Mr. Hughes gave her one-armed hugs on more than 10 occasions is unsupported by any evidence in the record. This type of conclusory and unsupported assertion has been rejected by this court in the case EEOC versus Xerxes.
So, but the district court essentially looked at the evidence, said that was consistent, and said that wasn't severe and pervasive. So is your argument that it was really less than that, and therefore it's less severe and less pervasive? Or, sounds like you're questioning what the district court found, which you're certainly entitled to do.
I think, Your Honor, that the district court.
Let me just add, we're at summary judgment, as you know, you consider the evidence in the light most favorable to the non-moving party. So probably hard to say the district court abused that standard by talking about it. Maybe he did. I'm certainly open to hearing what you have to say. But
I think, Your Honor, the district court did an excellent job of looking at the evidence, separating the hyperbole, and accepting what was, to use your words, in the light most favorable to the plaintiff, and settled on more than 10. Our case, Your Honor, our argument is accepting that standard, that number, it's not severe or pervasive. But if the court were inclined to go down the road of continuous and everyday, our position is it absolutely should not do that, because the type of conclusory support has been rejected in Xerxes, in Evans versus Technologies Applications, Causey Bellog, and Carter v. Ball. Here, there's no evidence that anybody else saw this alleged everyday hugging. There's no evidence that she reported everyday hugging to her fiance. In fact, her fiance testified that he only knew about the welcome back hug and peck on the cheek. The evidence is she had a fabulous relationship with her mother, whom she saw every day and never told her about alleged everyday touching. She submitted a written statement on May 10th, 16 days after the April 24th welcome back hug. No mention of continuous touching. She met with Erica Garrett, who came into Roanoke to do a pulse check on May 1st and 2nd. She didn't even tell Ms. Garrett about the welcome back hug and a kiss, much less continuous everyday touching. Finally, she meets with Joe Taylor in June and tells him only about the welcome back hug and a kiss on the cheek. I offer the court those factual pieces from the record to demonstrate why the holdings in cases like Xerxes are sound and that the court should not consider the type of conclusory, it happened every day statement here, devoid of any record.
But assuming, as the district court did, 10 times or more, maybe even, let's call it, for present purposes only, maybe some number between 10 and 20, based on her deposition testimony. It was more than 10 times. I don't remember if it was more than 20. Why, can you just explain to me why that is not sufficiently pervasive to rise to the level of a hostile workplace environment?
Yes. There's no question that if Mr. Hughes touched Ms. Sowash 10 times or 20 times, and she didn't want him to touch her. Now, mind you, the evidence is she never told him not to.
But she reported it, right, several times?
Well, there's a dispute about that, but she did.
Let's assume she did.
Are you saying she did not report it to several supervisors?
For purposes of summary judgment, obviously the court can assume that she did, but there is no record evidence of that. But if I could, Your Honor, let me try and address your question. There's no sexual comments that occurred with respect to any of the touching. In fact, there's no comments at all. There's no evidence that it caused her not to be able to perform her job, to have to take leave, to take any time off. There's simply not the high level of harm that this court's jurisprudence has historically required in order to demonstrate the high threshold necessary for severe and pervasive harassment. The Hopkins v. Baltimore case, the Hartzell v. Duplex case, the Singleton case. There's an excellent case I'd refer the court to from Judge Brinkema out of the Eastern District. That's Freeman versus SAIC. This was a female on male situation, and the allegations were that the female supervisor stared at the man's groin, put her hand on his shoulder and side, grabbed his arms and commented on his biceps, playfully touched his lower back, rubbed his earlobe, told him his beard looked good, and allegedly touched him inappropriately 2 to 3 times a day. Judge Brinkema found that that conduct, based on Fourth Circuit precedent, was not severe or pervasive. And I think, Your Honor, Judge Urbanski, as I said, he separated the wheat from the chaff, and he landed on the nugget. And what he said was, while Hughes' hugs, touching of Sowash's arm, kiss on the cheek, and occasional compliments about her appearance are inappropriate workplace behaviors, they do not cross the threshold of severe or pervasive conduct under Title VII. Moving to the because of sex prong, this prong is met, whether this prong is met depends upon the nature of the conduct involved and the context of the behavior. There are at least 3 ways a plaintiff can demonstrate this. One is earnest solicitation for sex. Another is...
Counsel, I want to hear what you're saying here. When you say there's 3 ways, is that based on Fourth Circuit law, or are you looking at that English district court case? I mean, one of the things that I wasn't entirely clear of is whether we have established factors. So are you saying that's established law, or is that saying what you think the three ways that can be done?
It is established law, but I want to be clear. The Oncology case was the first case to set forth these factors. This court in Lack v. Walmart highlighted them, and then more recently in Roberts v. Glenn Industrial, this court clarified that and said, these aren't the only three. There may be others. So that's why I said there are at least three. And I agree on very little with Mr. Grimes, except that in sexual harassment cases, you have to consider the totality of the circumstances. And the law is not a rigid model in order to determine whether sexual harassment has occurred. The facts are so varied and so different, it simply cannot be. But so here, there's no evidence of any solicitation, none. No asking out on a date, no private parts, no gropes, no sexual comments, nothing. And the undisputed evidence is that Mr. Hughes is gay. He's lived with the same man.
What does that matter?
Because
It's not about because of his sex or his sexual activity. It's because of the plaintiff's sex and whether he treats men and women differently.
I couldn't agree more, Your Honor. The key inquiry here is whether members of one sex are treated to disadvantageous terms and conditions of employment than another. But the reason his sexual orientation matters is because it removes the first vehicle, which is commonly used to prove because of sex, and in the majority of sexual harassment cases, where a man is behaving inappropriately towards a woman, there's often sexual interest that can be demonstrated to show that that's why he's behaving that way. My point is simply here.
So is your comment that that's not relevant to this, that shows there's not a solicitation type way to get to because of sex, or it's relevant beyond that?
No, it's relevant because it shows that Mr. Hughes was not interested in Ms. Soash romantically or sexually. Therefore, on the because of sex prong, Ms. Soash cannot avail herself of the earnest solicitation.
But that's not the only way you can have
That is correct.
sexual
That is correct.
because of sex conduct.
If Ms. Soash could demonstrate a general hostility towards women in the workplace, or if she could offer direct comparative evidence that shows men and women were treated differently. I submit to the court she doesn't do either of those two things. With respect to general hostility towards women, she relies on a comment that Mr. Hughes made to Erica Garrett as part of the investigation. And the comment was that the store manager was going to get upset because cute little girls were bringing their boyfriends into the store. There's no evidence in this record that that comment was made to her.
It seemed to me that there was at least possibly some evidence suggesting that this was a problem specific to women in the workplace between Mr. Hughes and women. But I'm not sure if we thought that we reached this question, the because of sex question, the district court didn't reach it, right? No one has ever looked at the record through this lens. Wouldn't we normally just remand and have the district court address this in the first instance if we thought it were dispositive? Or are you suggesting we should resolve it ourselves in the first instance?
You certainly don't need to resolve it, Your Honor, to resolve the case. The case can be resolved solely on severe or pervasive. The district court did not consider the because of sex prong.
Right, so no one has looked at the record no one has made this inquiry of this record. Is there enough here to get to a jury on whether this behavior was targeted at women?
I don't think there is, Your Honor.
I know you don't think there is, but I'm sorry, I meant no court has looked at
That is
that, right, okay.
That is correct. No court has adjudicated whether on these facts there was a jury question created. Presumably, if Judge Urbanski thought that the issue was such that it warranted further consideration.
And from a kind of, I guess, logic or following an analytical or structural basis, that really would come first before severe and pervasive, because it first has to be because of sex, and then if you discriminate because of sex, then and you don't show an adverse employment situation, you can still do it based on a hostile work environment. And so it's the district court's severe and pervasive conclusion. I don't know if he assumes expressly because of sex, but that's almost, it seems like what has happened. And then he goes, even assuming that, even though he probably doesn't use those words, it's not severe and pervasive. Is that right, kind of how that analysis will flow, or do you disagree with that?
I don't, Your Honor. I think from a logical perspective, one would typically look at the because of sex factor first and then move on to the severe or pervasive factor. But I'm not aware of any law which requires that sequential analysis, nor any case which faulted a lower court for not analyzing because of sex first. And obviously, I would be entirely speculating to opine on why Judge Urbanski ruled in this fashion. But I want to try and focus in on this idea about whether there's evidence in the record Mr. Hughes treated women worse than men. The evidence in the record is that he winked at least 2 men, and the evidence in the record is that 2 women, only 2, said that he had touched him. One was Ms. Soash, and one was Christy Thompson, who characterized a touch on the shoulder as him trying to be friendly or your girlfriend. She said that it did not have sexual connotations. She didn't like it because she has a medical condition that made it painful. So this is not a case, despite the hyperbole, in which Mr. Hughes, at least according to the evidence, has engaged in wholesale abusive behavior towards women. With respect to the Terrell Declaration, it's chock full of hearsay. But more importantly, it was drafted in October 2020 and signed. Discovery didn't close until March 2021. It was never produced. It was never produced. And it should have been, and there's never been an explanation why. Beyond that, it doesn't offer any context. It is rife with opinion, and it doesn't provide the sort of texture or factual support.
Did the district court resolve this Terrell Declaration issue?
District court did not, Your Honor. The district court did not. We did not move to strike, although as the case proceeded to trial, we did file a motion in limine on it. But we did not move to strike it, and the district court did not rule. Similarly, the district court did not directly rule on the issue of whether the notes which were allegedly made of each instance of harassment should have been produced or used in the context of summary judgment. Finally, on the assault and battery claims, Bayless is the driver here. It's the same scenario.
Can I ask you a question about that, particularly on the battery end of things? Because it looked to me like Bayless, is certainly very close to on all fours with some of the conduct in this question, the welcome back, hug and kiss, but maybe not so much with the rest of the conduct. And I did just have a question about how the Title VII standard kind of intersects with the Virginia battery standard, which is that the conduct has to be offensive and rude, insolent, or angry. Is it possible that conduct can be offensive and rude under the Virginia standard without being severe or pervasive under Title VII? Do you know what I'm saying?
I do.
Because I'll tell you why I'm asking this is because I feel like we've said this a million times, that just because your supervisor, just because the conduct is offensive and rude, that doesn't mean you were sexually harassed under Title VII. That's a different standard. The workplace, it has to affect your workplace conditions. And just because it's rude and obnoxious doesn't mean it does that. So it occurred to me there might be space between these two standards, like rude and obnoxious might be enough under Virginia law, even if it's not enough under Title VII.
I'm not aware of any case or legal
I couldn't find
authority
one,
which
yeah.
has opined on that issue, but as the court provides it, I think that makes good sense. There's certainly a number of situations which might be offensive. For example, a single incident that wouldn't rise to the high level required under severe or pervasive. In conclusion, no reasonable juror could find that Mr. Hughes sexually harassed Ms. Sowash. The behavior here wasn't severe or pervasive. It wasn't because she's a woman. It simply doesn't rise to the high level that this court has repeatedly required in order to demonstrate severe pervasive harassment in order to ensure that the courts do not become tribunals of workplace misconduct as opposed to actionable discrimination. Thank you.
All right, thank you, Mr. Grimes.
Yes, my opponents made some statements that are just absolutely not true, and I want to correct them. First, with respect to the plaintiff's complaints to Eric Garrett, I turn your attention to page 8 of the reply brief, and here's what the plaintiff told Erica Garrett, quote, this is in May of 2018. I talked to her about what David was doing to me and how he was treating me. My main concern was the issues I had going on with David, that he was touching me, hugging me, making me feel uncomfortable. He kissed me. The remarks and the comments that he would make towards me, I did tell her, and she told me that she would take care of it. That's in the joint appendix at pages 308, 309.
Counsel, can I ask you a question? So the district court credited that there were reports of Hughes's conduct and said that meant that the subjective component is met. Is it your contention that it also bears on the objective component, or is this mostly about the subjective component and then the imputation prong?
It bears upon the objective component as well. For example, it's reversible error not to look at the cumulative impact of repeated touching. The district court overlooked that altogether.
But I don't know, what does that have to do with the reporting? I'm sorry, maybe I was unclear. I meant, do you think that the fact that she reported the conduct up in the chain of authority, it clearly bears on the subjective component, as the district court held? I think you referred earlier to how it would affect the imputation, the last prong, whether you can hold the company liable. But do you also think that the fact of the reporting bears on the objective prong of severe and pervasive?
It does, in the sense that a jury could find that any reasonable woman would have felt the same way and done the same thing. And Erica Garrett wrote up in her report of May 15, 2018, she wrote, and again I'm quoting page 13 of the reply brief, quote, ASM David Hughes is the major cause of the problems in the building due to his inappropriate behavior such as touching female associates. Close quote. That's joint appendix at 390 and 396. Moving with the speed of molasses, 2 months later, marshals wrote up David Hughes. And this is on page 14 of the reply brief, joint appendix at page 395. We have the write-up. Quote, David has violated our code of conduct by exhibiting unprofessional and inappropriate behavior, such as comments and unwelcome physical contact toward associates in the store. Close quote. There's no evidence he ever touched one male associate, no evidence whatsoever. So to pick up on Judge Quattlebaum and Judge Thackeray, your comments under Bostock versus Clayton County, his sexual orientation is another red herring. It doesn't matter to your analysis whatsoever. The other misstatement was...
Are you saying it doesn't matter, it doesn't, it's not a showstopper, or it doesn't matter even to the proving because of sex through a solicitation claim?
It doesn't matter to proving the sex through solicitation even. And at first, the district court never passed on the question.
Agreed.
Not developed on that.
Right.
So, and finally, the last mistake, to say this is all about a kiss on a cheek on April 24, 2018, again, I draw your attention to the reply brief at page 11, completely out of context. That occurred on April 24, 2018. Sowash said that, quote, He just pulled me in close to his body, and that's when he kissed me on the cheek, close quote. That's in the joint appendix at 362. The point is, the harassment began in February. The touching began in February. It had gone on already then for 2 months. It ended in June. It went on for another 2 months after this kiss on the cheek. So that's not, if that's all we had, we wouldn't be here. Let me just say that.
But it was an important part of your case before the district court. I mean, in fairness, it's not like your colleagues pulling it out of thin air.
I said, if that's all that
Right,
we
okay.
had, if that's all that we had, we wouldn't be here. We had months of unwanted touching while saying things like, don't report me again. So, thank you very much for your time.
All right, thank you both for your zealous representation on behalf of your clients. We appreciate it, Mr. Baldwin, Mr. Grimes. And we'll now adjourn court until this afternoon.